private counsel/lawyers for elective local officials Alinsik v RDC and Mayor Ponseca. Facts: Zonseta Alinsik had been a regular employee of the municipal government of Escalante, Negros Occidental. When she received a permanent appointment as Clerk 3 in the office of the Municipal Planning and Development Coordinator of the same municipality. Mayor Rolando Ponseca detailed her to the office of the mayor. On June 19, 1992, Zonseta absented herself from work allegedly to attend to family matters. She had asked permission from the personnel officer but not from the mayor. Mayor Ponseca issued Office Order No. 31, suspending Zonseta for 1 month and 1 day commencing on June 24, 1992 for a simple misconduct which can also be categorized as an act of insubordination. The order also stated that the suspension carries with it forfeiture of benefits such as salary and para and leave credits during the duration of its effectivity. Zonseta filed with the RDC a petition for injunction with damages. She alleged that her suspension was an act of political vendetta. Mayor Ponseca, through private practitioner Samuel S.M. Lezama, claimed that Zonseta had not yet exhausted administrative remedies and that her suspension was in accordance with law. The foregoing elicited a motion from the petitioner, praying that the answer be disregarded and expunged from the record, and that the respondents be all declared in default on the ground that since the respondents were sued in their official capacities, not including their private capacities, they should have been represented by either the municipal legal officer or the provincial legal officer or prosecutor as provided for by Sector 481N of the Local Government Code. It also cited Sector 1 of Rep. Act No. 10 and Art. 177 of the RPC, which penalizes usurpation of public authority. The respondents opposed the motion, manifesting that the municipality of Escalante has no legal officer. They asserted that both the Local Government Code and the Administrative Code of 1987 do not have any provision relative to the duty of any provincial legal officer or prosecutor to represent a municipality or its officials in suits filed against them by an employee or a private individual. They contended that it was unnecessary to provide such a provision because their administrative and judicial rulings sustaining the validity of the employment of a private counsel by municipal officials. The lower court issued the order denying the motion on the thesis that since the appointment of a legal officer was optional on the part of the municipal government, Art. 481, third paragraph, Local Government Code, and the municipality of Escalante had not, in fact, designated any such legal officer. Petitioners moved to declare respondents in default for having retained a private counsel was not thereby legally sustainable. Issue 1. A private counsel may represent municipal officials sued in their official capacities. Ratio. It appears that the law allows a private counsel to be hired by a municipality only when the municipality is an adverse party in a case involving the provincial government or another municipality or city within the province. This provision has its apparent origin in the ruling in Digia v. the Auditor General, where the court held that the municipality's authority to employ a private attorney is expressly limited only to situations where the provincial fiscal would be disqualified to serve and represent it. With Sector 1683 of the old Administrative Code as legal basis, the court therein cited Enriquez, Sr. v. Jimenez, which enumerated instances when the provincial fiscal is disqualified to represent in court a particular municipality. If and when original jurisdiction of case involving the municipality is vested in a Supreme Court, when the municipality is a party adverse to the provincial government or to some other municipality in the same province, and when, in a case involving the municipality, he, or his wife, or child, is pecuniarily involved, as heir legatee, creditor, or otherwise. Thereafter, in Ramos v. Court of Appeals, the court ruled that a municipality may not be represented by a private law firm which had volunteered its services gratis, in collaboration with the municipal attorney and the fiscal. as such representation was violative Sector 1683 of the old Administrative Code. This strict coherence to the letter of the law appears to have been dictated by the fact that the municipality should not be burdened with expenses of hiring a private lawyer, and that the interests of the municipality would be best protected if a government lawyer handles its litigations. But would these proscriptions include public officials? Not necessarily. It can happen that a government official, ostensibly acting in his official capacity and sued in that capacity, is later held to have exceeded his authority. On the one hand, his defense would have then been underwritten by the people's money, which ordinarily should have been his personal expense. On the other hand, personal liability can attach to him without, however, his having had the benefit of assistance of a counsel of his own choice. In Korea v. CFI of Bulacantan, the court held that in the discharge of governmental functions, municipal corporations are responsible for the acts of its officers, except if and when, only to the extent that they have acted by authority of the law, and in conformity with the requirements thereof. In such instance, this court has sanctioned that representation by private counsel. In one case, we held that where rigid adherence to the law on representation of local officials in court actions could deprive a party of his right to redress for a valid grievance, the hiring of a private counsel would be proper. And, in Albura v. Torres, this court also said that a provincial governor sued in his official capacity may engage the services of private counsel when the complaint contains other allegations in a prayer for moral damages, which, if due from the defendants, must be satisfied by them in their private capacity. The key then to resolving the issue of whether a local government official may secure the services of private counsel, in an action filed against him in his official capacity, lies on the nature of the action and the relief that is sought. While the petition below was filed against respondents as public officials, its allegations were also aimed at questioning certain acts that can well bring the case beyond the mere confines of official functions, thus too. 12. These actuations of the respondent mayor in detailing petitioner to his office and eventually suspending her from work, particularly the latter, are no doubt respondent mayor's political vendetta of petitioner. A vengeance unleashed on her for her children's and family's not going with and voting for him in the May 11, 1992 election, and instead supporting the candidacy of their relative candidate in said election, who was his great worry at that time. 2. 13. The aforesaid acts of respondent mayor are clearly, apparently, and obviously a political harassment and persecution, oppressive, acts of vindictiveness, a grave abuse of executive discretion, despotic, unjust, unwarranted, condemnable and actionable. The indefinite detail order and, especially the suspension, were not done in good faith, not for a valid cause, and done without giving petitioner opportunity to be heard, hence null and void for being violative of petitioner's legal and constitutional right to due process. The petition then went on to claim moral and exemplary damages, as well as litigation expenses, as shown by its prayer. Moral damages cannot generally be awarded unless they are the proximate result of a wrongful act or omission. Exemplary damages, on the other hand, are not awarded if the defendant had not acted in a wanton, oppressive, or malevolent manner, nor in the absence of gross or reckless negligence. A public official, who in the performance of his duty acts in such fashion, does so in excess of authority, and his actions would be ultra vires that can thereby result in an incurrence of personal liability.